the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Ivo Skoric versus City of Rutland, case number 24 AP 192. Appellant Ivo Skoric is self-represented. Representing the appellee, the City of Rutland, is Mary Kate Kelly.
Okay, thanks very much, and good morning again, everybody. Mr. Skoric, can you hear me, sir?
Yes, sir, I can hear you. Can you hear me?
Yes, I can hear you, and so you understand you have 5 minutes. We'll try to give you an alert when you have about a minute remaining. So please go ahead.
Okay, good morning, Your Honors. It's a pleasure for me to be here. I just want to be very brief. 20 years ago, I bought a 2-unit house in Rutland. In front yard was shaded by a beautiful old growth maple tree. The downstairs tenants parked in the left-hand driveway and the upstairs tenants parked in the right-hand driveway. My family decided to make our home upstairs. Then, last summer, during the extraordinary paving extravaganza, the new city regime decided to block the left-hand driveway with an 8-inch tall concrete curb and cut the tree into pieces. Since then, they have defended those actions as their right. They say the tree was on their property, while just incidentally shading mine. It was old, lifting sidewalks, but conveniently, their paid expert said not lifting my porch. That was lifted, perhaps, by an act of God. They say the curb was always there, pre-existing, albeit sunken, and I, or rather my tenants, were driving over it unlawfully in the, quote, parking spot located on what used to be the lawn to the left of driveway, end of quote. I bet 300 years ago, this was all a forest. However, the city did not submit any piece of evidence that this was a lawn at some point in time, despite that I requested such evidence. For the 20 years that I have owned the property, there was never a lawn here. When I bought this house, I bought it under the premise that it has separate driveways for myself and my tenants. This is how the property was sold and represented to me by the seller, inspector, real estate agent, lawyers, the city. And in 20 years, nobody raised an issue of the sunken curb. Nobody in the city said I or my tenants had to apply for a special permit to drive over the sunken curb. The statute of limitations to telling me that now has, I believe, long expired. The current situation should be accepted as the new reality, the right established through continued use. And the city made a mistake in not approving the additional curb cut. Instead, the city is clinging to the word pre-existing, just like health insurers denying your claim. And they repeat the mantra of public safety and public good as if they are not aware that the public safety and public good have been the fig leaf for authoritarian regimes and constitutional takings since the Robespierre's 18th century France. But the public is all of us, including me and my tenants. And we also have the right to use public roads to access our homes reasonably and conveniently. It is us who pay the property taxes and sales taxes that enable the public works. Yet, the city believes that it has the sovereign right to act without our consent, even when it is our property that is damaged and our lives that are inconvenienced. There is actually no word in the appellee city's brief about my property being a 2-unit and having 2 families living in it, both deserving to keep their own accessible driveways that they enjoyed for decades without any question or interruption, and to not instead be forced into a potentially unsafe shared driver situation by the arbitrary and capricious action of the city cutting their access off by blocking it with a concrete curb. And if that tree created a safety hazard for 2 decades by lifting the sidewalk, how come the city had waited so long to remedy the situation?
Mr. Skoric, you have 1 minute.
Yes. Why did it let my family live with that hazardous situation right in front of our home for so long? I wonder if anyone will ever take the responsibility for that omission. That said, my claim still stands. The city reduced the value of my property by cutting off the shade tree and by blocking one of the driveways with a concrete curb. And furthermore, they created a potentially publicly unsafe situation by forcing the landlord and the tenants to share the driveway. I think that's it for my oral argument.
All right. All right. Thank you. Thank you very much. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
May it please the court, my name is Mary Kate Kelly. I represent the city of Rutland.
Thank you.
The trial court's grant of summary judgment in this matter should be affirmed. There are no factual disputes supported by admissible evidence. The city replaced curbing in front of Mr. Skoric's property as part of a reconstruction project for the street. The replacement of curbing as part of the city's reconstruction of the road was not arbitrary. As the photographic evidence shows, the curbing and sidewalk were in need of repairs. The reconstruction was also within the city's rights and its governmental function. Mr. Skoric's tort claims against the city are foreclosed by governmental immunity. The city's reconstruction project, including the replacement of sunken curbing on Rutland Street, was a governmental function for which it had immunity.
Ms. Kelly, could he have received an easement or some type of right of way because of the lack of a curb there that had sunken down?
Under Vermont law, no prescriptive easement is available against the municipality. There is an exception, but it does not apply. The sidewalk and curbing protecting the sidewalk and are clearly were for public use and safety and not outside the scope of the rule that an easement is not available against a municipality as prescriptive easement.
And could he have at some point requested the curb cut at that?
He did request a curb cut and the curb cut was denied. When the city, if the court reviews this, the photos in the file, there's a before and after photo. And the photo shows that there was a curb cut for on Robin Street, a curb cut on the neighbor's property. And then the curb started at Mr. Skoric's property. His access under the title report and deeds all provided that his access was from Pine Street through an easement over his neighbor's property. Nonetheless, the city widened the access to 20. Mr. Skoric says 20 feet. The city says 25 feet. But even at 20 feet, if you look at the photos, Mr. Skoric has plenty of room to access his property from Robin Street. What he wants is a wider access so he can also more conveniently access a place where he parked on the
access. The way I read it is he's looking for two access points.
Two access points from Robin Street, or a wider access. And again, if you look at the before and after photos, I think those will clearly show, what the city gave him and what he's looking for.
Sure.
And again, he also has that access from Pine Street, and that's the access given to him in his deeds and in the again, that's an easement over his neighbor's property. In terms of the parking space itself, this parking space is just to the right of, if you look at using the photos as a reference, it's to the right of his.
You
porch.
have 1 minute, counsel. 1 minute.
It's to the right of his porch and sidewalk. The city does not regulate whether you can park there or not. He can still park there. As he says, it is just more convenient for him to park for the access to be wider to access that parking space. In terms of his claim about the shade tree in his complaint, he sought monetary damages for the shade tree caused damage to its porch and sewer line. Those claims were disposed on summary judgment because the statute of limitation had run on his tort claim. And as he acknowledged in his pleadings, the shade tree, another tree on the property, through the neighbor works report inspection showed that was
All right.
causing damage.
All right. Your time has expired. Thank you very much. Does the appellant have time?
Appellant has 19 seconds remaining.
Mr. Skoric?
We are obviously talking past each other, me and the appellee. They think they have the right to do that, and I think that regardless of them having right to do it, they should consent. They should ask the consent of the citizens who live, in that property that they are doing the public works near. Because we look at our front yard every morning. It is not city that looks at my front yard every morning. It's me who have to live with that.
Thank you, sir. Your time has expired. Please.